New H-1B visa rules of the USA, 2026. The United States has introduced major changes affecting H-1B employers, foreign professionals, international students, and applicants seeking an H-1B visa through the annual CAP process. 1. H-1B lottery is no longer completely equal. The biggest change for the FY 2027 H-1B CAP season is a new, weighted selection process. Under the previous beneficiary-centric lottery, each unique beneficiary generally had the same chance of selection, regardless of salary level. Under the new system, USCIS gives more selection weight to registrations offering wages corresponding to higher occupational employment and wage statistics, or OEWS wage levels. The selection weighting is wage level 4, entered into the selection pool 4 times, wage level 3, entered 3 times, wage level 2, entered 2 times, wage level 1, entered 1 time. This rule became effective on February 27, 2026, and applies to the FY 2027 H-1B CAP registration season. It does not guarantee selection for a high-wage applicant, and Level 1 or Level 2 workers can still be selected. However, higher wage levels now receive better statistical chances. DHS estimated the following selection probabilities under the new system. Level 1, approximately 15.29%. Level 2, approximately 30.58%. Level 3, approximately 45.87%. Level 4, approximately 61.16%. These percentages are government estimates, not guaranteed results for every CAP season. Actual chances depend on the number and distribution of registrations submitted. 2. USCIS uses the lowest wage level when one person has multiple registrations. The selection process remains beneficiary-centric, meaning USCIS selects unique beneficiaries rather than rewarding a person merely because several employers submitted registrations for them. A major new safeguard applies when different employers register the same beneficiary at different wage levels. USCIS generally assigns that person the lowest wage level listed among all registrations submitted for them. For example, suppose Employer A registers the applicant at Level 4. Employer B registers the same applicant at Level 2. For selection purposes, the beneficiary may be treated as Level 2, not Level 4. This provision is intended to prevent employers from submitting artificially high wage levels merely to improve selection chances. 3. Employers must report the correct wage level. During registration, the employer must select the highest OEWS wage level that the offered wage generally equals or exceeds for the relevant occupation or SOC code, the intended employment location, and the salary being offered to the worker. Employers should not simply choose Level 4 to obtain better lottery odds. The information in the registration must remain consistent with the labor condition application, Form I-129, and supporting documents. Providing an incorrect wage level may lead to questions, rejection, denial, revocation, or allegations of misrepresentation. 4. Additional $100,000 payment for certain new H-1B petitions. A presidential proclamation issued in September 2025 requires certain new H-1B petitions filed on or after September 21, 2025 to be accompanied by an additional $100,000 payment as a condition of eligibility. This requirement does not necessarily apply to every H-1B filing. Its application depends on the type of petition, the beneficiary's circumstances, and any applicable exemptions or national interest exceptions. USCIS provides separate payment instructions and guidance for affected petitioners. The proclamation was designed to remain effective for 12 months unless extended. Therefore, based on its original term, it is scheduled to expire around September 21, 2026, unless the government extends, replaces, or modifies it. Employers should not assume that the ordinary H-1B filing fees alone are sufficient. They should check the current USCIS instructions immediately before filing. 5. Higher premium processing fee beginning March 1, 2026. The premium processing fee for eligible H-1B Form I-129 petitions increased from $2,805 to $2,965. Premium processing is optional. It provides faster USCIS action within the applicable premium processing timeframe, but it does not guarantee approval. USCIS may approve the petition, deny it, issue a request for evidence, or take another qualifying action. 6. Stricter specialty occupation connection. An H-1B position must require highly specialized knowledge and normally require at least a bachelor's degree or equivalent in a directly related specialty. The current rule clarifies that directly related means there must be a logical connection between the required degree field and the duties of the offered position. A job may accept more than one degree field, but every accepted field must logically relate to the actual duties. For example, an employer cannot list several unrelated degrees merely to make the position appear flexible. USCIS considers the worker's actual coursework, training, and experience, not only the title printed on the degree. Relevant education and progressively responsible experience may still be used to establish degree equivalency where permitted. 7. Evidence of a real job must be available. The employer must demonstrate that a genuine specialty occupation position exists for the beneficiary as of the petition's requested start date. USCIS may review detailed job duties, the employer's business activities, organizational charts, client contracts, statements of work, work orders, end client letters, the labor condition application, the beneficiary's qualifications, and evidence that the employer can actually employ the worker. A vague job description containing generic words such as develop, analyze, or manage may not be enough when it does not explain the specialized duties. 8. Third-party worksite rules. When an H-1B worker will be placed at a third-party company and will effectively fill a position within that company's organization, USCIS may examine the third party's requirements for that position. The petitioner may need documents such as master service agreements, statements of work, end client letters, project descriptions, organizational charts, and evidence showing who controls and supervises the work. The rule does not ban consulting or staffing companies. However, the petitioning employer remains responsible for establishing that the worker will perform genuine specialty occupation duties and that the employment complies with the approved petition. 9. Expanded USCIS site visit authority. USCIS may conduct compliance inspections at the employer's headquarters, satellite offices, the beneficiary's worksite, a third-party client location, or the beneficiary's home when the employee works remotely. Site visits can be unannounced. If USCIS cannot verify the employment because the petitioner, beneficiary, or third party refuses to cooperate, the agency may use those findings when deciding whether the petition remains eligible. Employers should ensure that addresses, duties, work arrangements, and client information match the approved petition. 10. H-1B rules for company owners and entrepreneurs. A company can file an H-1B petition for a beneficiary who owns or controls the petitioning business. However, a beneficiary owner must still perform qualifying specialty occupation duties, have a genuine employer-employee relationship with the company, follow the terms of the approved petition, and spend the majority of the authorized time performing specialty duties rather than only general ownership or investment activities. This provision can benefit startup founders, but beneficiary owner petitions may receive additional scrutiny regarding business operations, company control, and the availability of qualifying work. 11. More deference for H-1B extensions. When USCIS previously approved an H-1B petition involving the same parties and substantially unchanged facts, adjudicators generally give weight or deference to the earlier decision. However, a previous approval does not guarantee an extension. USCIS can reach a different decision when there was a material error in the previous approval. The facts have materially changed. New information affects eligibility. The employer or employee violated status, or the earlier approval was inconsistent with law or policy. 12. Improved cap-gap protection for some F1 students. Eligible F1 students with timely filed cap-subject H-1B petitions may receive an automatic extension of F1 status and, where applicable, employment authorization under the cap-gap provisions. The modernization rule extended the potential cap-gap period to reduce employment interruptions when an H-1B petition remains pending beyond October 1st. Cap-gap protection is not based merely on submitting an electronic registration. The selected employer must file a qualifying H-1B petition while the student satisfies the applicable F1 and OPT requirements. 13. Current Form I-129 must be used. Employers must use the Form I-129 edition currently accepted by USCIS. A filing may be rejected when an outdated form edition is used, required pages are missing, the wrong filing fee is submitted, the form is unsigned, the wrong filing address is used, or required supplements are incomplete. Employers should download Form I-129 directly from USCIS immediately before preparing the filing rather than reusing an old saved copy. 14. Signature requirements. The so-called USCIS signature rule is not a completely new H-1B law created in July 2026. USCIS generally requires a valid signature from the authorized employer representative. A scanned or photocopied signature may normally be accepted when it is reproduced from a genuine handwritten signature. Common mistakes include leaving the signature field blank, merely typing the signer's name, using a signature-style font, having an unauthorized employee sign, allowing the attorney to sign the employer certification, submitting the wrong signature page, or omitting the signed page from the package. A signature problem can result in rejection, delay, or loss of an important filing date. 15. H-1B cap has not been increased. The regular annual H-1B numerical limits remain: 65,000 under the regular cap and 20,000 under the U.S. advanced degree exemption. The new rules change how cap registrations are selected, but they do not automatically increase the statutory number of available H-1B visas. Who is most affected? The new rules particularly affect entry-level applicants offered Level I wages, international students moving from F1 OPT to H-1B, Indian technology professionals, IT consulting and staffing companies, employers with third-party client placements, startup founders and beneficiary owners, companies filing new overseas H-1B petitions, employers using premium processing, and applicants registered by more than one employer. What employers should do before filing? Employers should verify: 1. The correct wage level was selected. 2. The offered salary matches the occupation and work location. 3. The registration information matches Form I-129 and the LCA. 4. A genuine specialty occupation position is available. 5. The degree fields logically relate to the duties. 6. Third-party contracts and project documents are complete. 7. The correct Form I-129 edition is used. 8. All required signatures are valid. 9. Every filing fee and additional payment is included. 10. The petition is filed within the period shown on the selection notice. 11. A complete copy of the final petition is retained. Current USCIS instructions are reviewed immediately before submission. Important conclusion: the most significant 2026 change is the replacement of the equal cap lottery with a wage-level weighted selection system for FY 2027. Higher wage registrations now receive more entries in the selection pool, while entry-level applicants have lower estimated odds. At the same time, employers face higher costs, stronger compliance checks, detailed third-party worksite requirements, and increased scrutiny of the relationship between the offered job, required degree, and actual duties. An H-1B registration selection only allows the employer to file a petition. It does not mean the H-1B petition or visa has been approved. Disclaimer: this information is for general educational purposes only and is not legal advice. H-1B rules, government proclamations, fees, exemptions, and filing instructions can change. Employers and applicants should review the latest USCIS, Department of Labor, and Department of State guidance and consult a qualified U.S. immigration attorney for advice about a specific case.